Great. Good evening, everyone. Masa al-khair. My name is Maurice Pomerantz. I'm the executive director of the NYU Abu Dhabi Institute. This, as many of you know, we're an interdisciplinary center for advanced research, artistic creation, and public outreach, which is, of course, why we're here tonight, in a way. I'm also a professor of classical Arabic literature here at NYU Abu Dhabi. Before we get on with tonight's lecture, I'd like to tell you about some of our upcoming events happening here in A6, either in this auditorium or the one adjacent. On this Wednesday, January 29th, we have a panel discussion entitled Environmental Toxins and Everyday Life, which will provide a closer look at local opportunities for impact. This is a talk which we're doing in collaboration with the Department of Health and the Abu Dhabi Early Childhood Authority. The panel will be looking at the role of environmental toxins in shaping health and well-being, and especially looking at impacts on fertility, birth weight, and children's academic and developmental outcomes. On Thursday, February 6th, it's our pleasure to be inviting Riken Yamamoto, who is the current Pritzker Architecture Prize laureate of 2024-25. This is a talk we're doing in partnership with the Abu Dhabi Festival, Maharajan Abu Dhabi. He's going to be speaking about the transformative power of architecture in shaping communities. The talk is entitled Crafting Tomorrow, Riken Yamamoto's Architectural Journey. And on February 10th, we have Jack Goldstone, Professor of Public Policy and the director of the Center for Social Change at George Mason University, who'll be speaking on the end of global population growth, boon or doom, which I think is quite self-explanatory. You can register, of course, for all these talks online. Please follow us on social media, Instagram, Facebook, LinkedIn, etc. Tonight, it is my pleasure to be handing over the floor to my colleague, Professor Rosemary Byrne, who's a professor of legal studies here at NYU Abu Dhabi. Professor Byrne is a graduate of Barnard College, Columbia University, and holds a JD from Harvard Law School. She's been a significant voice in the field of international human rights law. Notably, Professor Byrne has served as a human rights commissioner for the Irish Human Rights Commission, which was established in the aftermath of the Good Friday Agreement. She went on to chair the scientific committee of the EU Fundamental Rights Agency. Professor Byrne's expertise has taken her around the world. She's been a visiting professor at Sciences Po in Paris, the China University of Science and Law in Beijing, Harvard Law School, Jawaharlal Nehru University in New Delhi, and other locations. And in many ways, I can't think of a better interlocutor for tonight's important conversation. So I cede the floor to you. Thank you.
Good evening, and thanks for coming tonight for our conversation about achieving justice in the devastations of modern war. And our guest tonight, as you know, is Judge Erik Møse, who's an international criminal jurist. And I think his eminence in the field is pretty self-evident. He's currently the chair of the UN Independent Commission of Inquiry on Ukraine. He's been the president of the International Criminal Tribunal for Rwanda, where he was also a judge for 10 years in trials that were some of the most significant trials of extreme atrocities in conflicts since Nuremberg and Tokyo. He's a former judge of the European Court of Human Rights and of the Norwegian Supreme Court. And he has a much longer list of engagements in critical moments in the formulation of human rights law, in particular with respect to the prohibition against torture. And just one thing that I'd like to point out or to note before the conversation begins tonight is that I think the interest in this discussion is in part because there's an awful lot of despairing wars across the globe right now, and they're marked by a commission of atrocities. And that actually we take it for granted in this moment in time that victims of extreme crimes now demand justice, and it's expected that they receive it, even if the international criminal justice system is pretty frail. That there's been a real transformation, and this is because there's been an evolution of international criminal law. And I think it's important to kind of recognize the extent to which that's had an impact on the way that we expect accountability. And the observation that I'd like to make about Erik Møse's career is, before I turn the floor over to you, is that this evolution didn't happen in some abstract way. It's not a coincidence that effectively there were a small group of pioneering international criminal jurists who shaped the way that we now think about international crimes. I mean, it's really remarkable what they did, what they continue to do. And they did this often in circumstances that were extremely difficult. And Erik Møse was a really central figure in this process. And so it's a real honor to have him here tonight at the Institute. And I'm really looking forward. It's a privilege to be speaking with him. But before we begin, Judge Møse had kindly agreed, as there are many non-specialists in the audience, to situate our conversation by giving a background, by giving a context for international criminal justice. So I'd like to ask you if you could welcome him to the podium, and we'll begin our evening, if you will be so kind as to give us some background.
Well, dear participants, let me first thank the organizers for having invited me all the way to Abu Dhabi. I'm usually positioned in Oslo, Norway, but it's a pleasure to be here, and I'm already, having been here a couple of days, quite impressed by the university. I would also say that it is a pleasure to be together with Rosemary Byrne, who visited the tribunal, the Rwanda tribunal. I think in total she spent some time there, maximum with some interruption, during 18 months to make research. And it's really nice to see you again. The only problem is that she's exaggerating my achievements and my influence. So that is a weakness she has, but we have to bear with that. Thank you for your kind words. So the question in the title, also the title of this seminar behind me on the wall, whether justice can be achieved, that in a way requires some kind of an answer. But before doing that, we have agreed, as mentioned by Rosemary, to put it a bit in context. So the answer will not follow now, but generally during the discussion, the exchange. But here is some kind of a framework or an overview. Very briefly, let us all agree, and that's also because, of course, we have persons here with different backgrounds. Now, following the atrocities of the Second World War and also the trials in Nuremberg and Tokyo, it was clear that for the international community that there was a need to increase the protection of the individuals. And on 9th December 1948, the General Assembly adopted the Convention on Genocide, which for the first time defined the word genocide, the concept which had not been on the legal table previously. And that convention also has a clause later in the text saying that it is expecting that an international criminal court will be coming. But it didn't exist then, and the convention in itself did not establish any court. And then on the next day, the 10th December, the Assembly then adopted the well-known Human Rights Declaration. And again, with that declaration, with civil political rights, economic, social, cultural rights, the plan was to continue the work there by drafting binding conventions. So in a way, there were two paths that were indicated during those 2 days. An attempt to make courts in the future and binding conventions. And we will just follow these two paths very briefly. It's to be noted that they were both rather slow. If we first take the declaration, we know that the first binding UN convention only came in 1966 with the covenants on civil, political, and on economic, social, and cultural rights. And on the universal level came then the European Convention, the African Convention, and and some other regional conventions later. And the point with those conventions was simply that the states have the responsibility to ensure the rights and ensure and respect the rights of individuals, and that is then subject to supervision by the entities established by each convention. So the point here is state responsibility. But the other path, the other follow-up, was about, it took much longer. Of course, there were norms being developed, for instance, the Geneva Conventions regulating rights of individuals in armed conflicts, and the additional of 49 and the additional protocols of 77. But finally, in 1998, 50 years after the declaration, came then the adoption of the ICC's Rome Statute, establishing the International Criminal Court, which has the competence to adjudicate the most serious crimes: genocide, crimes against humanity, and war crimes. And later, following the so-called Kampala amendments, aggression, the crime of aggression, was added. Now, when it comes to this follow-up, the point was individual responsibility, with other words, accountability for individuals. And the ICC then, the point is that when national courts are unable or unwilling to initiate criminal proceedings, then the ICC is there as a complementary solution. And just to avoid any misunderstanding, ICC is in The Hague. Of course, the International Court of Justice is also in The Hague, but that is a quite different court, of course. And that is about state responsibility, duties, and rights, not about what we are talking about today. Typically, the recent cases about genocide and Israel and these more recent proceedings. Now, in the 1990s, while we were waiting almost in a way for the ICC, there was a need to set up the two ad hoc courts, and we will come back to them later in the conversation. But the point was that both the Yugoslav Tribunal, the ad hoc tribunal for the former Yugoslavia, and the tribunal on Rwanda, the genocide there, were established in 1993 and 1994. So these were the first international courts in this waiting period. And in addition to that came other specific courts. So these are courts with specific competence relating to specific countries within specified time periods. In addition to these two, we also had the Sierra Leone court. That court is perhaps most known because of the trial of Charles Taylor. We have the Extraordinary Court for Cambodia, which also dealt with such cases, and that related to the Khmer Rouge atrocity. You remember Pol Pot, what happened in that period in 75 to 78. And finally, I will, in this context, limit myself to mentioning the Special Tribunal for Lebanon in 2007, which dealt with the assassination of Prime Minister Rafik Hariri and about 20 other persons. Now, all these specific courts that I've mentioned now have now completed their activity. So they are mentioned by me now just to show the development, because that now leads to the fact that now at the international level we have primarily only the ICC left, plus a few others that I may mention during our conversation. Since the Commission of Inquiry has been mentioned here, let me just say that that this is in a way mentioned. This is not a criminal court. Here we are talking about the following. Many of these courts which I've mentioned were set up following commissions of inquiry, looking into whether there was a basis to establish a court. Recently, there is also a new trend, relatively recently, namely that you may establish such a commission for the eventuality that there will be established new courts. And that happens to a considerable degree. For instance, we have such commissions regarding Syria, Sudan, occupied territories of Palestine, and, as I mentioned, Ukraine. And that brings me to the end of this brief introduction. Thank you.
Thank you, Erik. Now the conversation begins. And I think your overview is really helpful because it highlights this explosion of accountability mechanisms. And so my first question really gets to a more fundamental issue, and that is, does law really matter in conflict and war? Is the solution political anyway?
That is, of course, a good question, because it's easy to note that when the atrocities are ongoing, it's easy to think, what is the role played by the law? Yeah. Sometimes we get a bit disappointed. But the main point is that, yes, very often when it comes to the beginning of the conflict, that is more political. That is a decision by someone to start, for instance, invading another state or trying to attack another group. And also the end of the conflict has political elements, because it will mainly be a matter of political will, whether you will be able to end the conflict. And that is a matter of an overall assessment by both parties or by all parties. But in the middle, of course, their law is essential, because the whole issue about conduct of hostilities and how you deal with people in that period, their law absolutely matters. So the only addition I will make to this regards the first point, namely the question of the beginning of the conflict. And recently, you remember I said that there had recently been an amendment to the ICC statute, namely that the crime of aggression was added to the statute. And in that sense, there is no case law on this, because this is very recent. But it shows that even the beginning can raise legal issues, namely, did the authorities starting the conflict commit the crime of aggression? So that's it.
And bringing this back to sort of the law, I mean, you've been sitting in international criminal trial chambers since the beginning of the criminal justice system. And I was wondering if you could tell us, looking in hindsight, what is different now in 2025 from the way that international justice was operating in the early days in the 1990s? Mm-hmm.
I think much has happened. It's been a very rapid evolution. One could maybe talk about some kind of an explosion in this legal field. Because if you go back to only the 1990s, as mentioned in the introduction, there were no criminal courts in the beginning of the 1990s. There was no general criminal court. It was just in the making. And then came the two conflicts in Yugoslavia and the genocide in Rwanda. And that created some kind of a public uproar. Everyone saw these things on television, and it was a need. Everyone felt we had to do something. And as a consequence of that, that led to the Security Council, exceptionally, frankly, establishing these two tribunals, each by one Security Council resolution under Chapter 7 of the UN Charter, which is about peace, maintenance of peace. So this was and very important, and that in a way started the whole development. And why was that possible then? We know there is so much tension in the world now. And the answer is, of course, that at that time there was less tension, both in the world generally, between the previous blocs following the fall of the Berlin Wall. And in the Security Council, it was easier to obtain consensus if everybody thought that it was the right thing to do. So that's why it was possible. And it followed with the other special courts. It led to the same, rather, this was a very good time for international criminal justice. So that is one thing. Now I've mentioned the institution, which is new. The second part, which is a considerable change, is the change law. All these institutions have developed a rich case law, a lot of judgments, which are helpful for the future. A third, also legal issue, I think we can mention, is that as a consequence of these new courts and these new, and now I'm including also the ICC, which, as I said, came in '98 and started functioning in the early 2000, the years just after, 2004. The three crimes in the ICC statute, genocide, crimes against humanity, and war crimes, and possibly, and also later the aggression, that has now been incorporated in many states' legislation. So that is also important. It shows that both at the international level and the national level, there has been progress. And finally, and this is not a legal issue, but a practical issue, all those who worked in the international ad hoc tribunals of various kinds, they built up expertise. Judges, lawyers, people in the registry, you can witness protection officers, everyone. And all that specific competence, which was new, how do you do this at the international level, has then been transferred to subsequent tribunal, and you find them now, many of them in the ICC or in other courts. So these are the 4 points I want to stress when you ask that question.
Can I bring you back to Rwanda, which is the tribunal you know best? And when you think about those sort of happy days with the enthusiasm and when the tribunal was created, in your view, what were the expectations for the tribunal? And did you guys achieve them? Or to what extent did you achieve them? Because they were high expectations.
Yeah. Yes, there were high expectations. But you know, that is not anything that is specific to Rwanda. If you look at all the courts that have been established during all these years, including the ICC, there have been high expectations. I think everyone, the victims, the state concerned, the international community, all look to this institution, be it Rwanda or someone else, and say, listen, we have the great, we are looking at you now. What can you achieve? And this is a good thing because it shows that there is a need, it's the right thing to do. But it's also a risky thing because when the expectations are very high, they may be too optimistic. An international tribunal would have, in a way, to prioritize because it cannot possibly deal with all the perpetrators in the conflict. And that brings me to Rwanda. Rwanda, as you mentioned, 800,000 to 1 million Tutsi and moderate Hutus were killed. That means that the number of perpetrators may easily have been, I'm sure there is a correct number, but let me just say 200,000-300,000. How do you deal with 200,000 foot people? And you cannot leave that to an international court. The international court has to, in a way, prioritize. It needs an investigation strategy. It needs a prosecutorial strategy. And that means that it should mostly focus on the leaders. And why? Because leaders, if leaders are put to accountability, that shows one that no one is above the law. And that sends a very strong signal to everyone, also the foot people.
Well, let me ask you, it's a tall task. And when you started at the tribunal, there was really no system, international criminal justice system per se. What were the challenges of building up a system from scratch? Because you were really making everything up to a certain extent.
Let me first say that the challenges will differ somewhat from tribunal to tribunal. There is a difference between establishing a tribunal in The Hague and in Tanzania, where the Rwanda tribunal was at that time. There was absolutely no infrastructure. There was no courtroom, there was no prison, there was lack of electricity. The judges were reading at candlelight in the evening. Of course, there was electricity, but it was switched on and off all the time. But that is not a matter of principle. I'm just making the point that there are many, many challenges. Let's stick to the more principled issues, and that is what is really the important thing for any tribunal. And that is, first of all, to make sure that you conduct fair trials. And the reason why this is so important is that, you know, fair trial is, of course, judges and those participating, prosecutors and lawyers will, of course, that is part of their usual job. They come from their national level, and that they are used to this. But another thing is the perception. How do you show that it is, even if it is fair, they are doing their best according to normal parameters? How do you ensure that people understand it? And that is a very important challenge, because you need to show this is a new organ, suddenly an international body placed here with a lot of strange international people. We have never seen them before. So build up legitimacy, that's one thing. I think our court did that, but it's something you have to be independent, you have to be impartial, you have to show that you are doing the best. That is fairness. And then the other one, and that is what is more often mentioned, that is trial within reasonable time. And it is true that international proceedings, criminal proceedings, take longer normally than most cases at the national level. But that's because things are so complicated. It's going on in many languages. There are many questions that are, for instance, the documentation is very complex. And in addition to interpretation and translation, the number of witnesses, one party may well submit a list of 150 or 200 witnesses. And all this takes time. And all witness testimony is coming through interpretation in 3 languages. So you think this is time consuming. So that's it. And people get ill. What you do if a judge falls ill, what you do if a defense counsel needs to go back to their own country because they have a firm there. They can't go bankrupt because they are here. So you have to make breaks. All these are examples. What about illness of witnesses? You have to postpone the case. Now, these are just examples, but I'm just trying to indicate that for all these challenges, which are different from national jurisdiction, it happens much more often. It's difficult. For all that, you have to build up expertise how to reduce the effects and try to preempt that kind of problems. So that is, and I have one anecdote here which I think shows that is special. I remember one day in the courtroom when we had to postpone because defense counsel said, "Do you think we could postpone for 2 days? You see, the documents I was expecting came with a little plane over the jungle or whatever it was, and it fell down. So the documents defense counsel needed, one needed to find them somewhere. It doesn't happen mostly in other countries.
Well, I guess these trials, they weren't straightforward, but they're really recognized because of the convictions for genocide. And I was wondering if you could talk a little bit about why is genocide so important? Why do people care about it so much? And secondly, why is there this sort of unspoken hierarchy about crimes? The classification of genocide and crimes against humanity. If you lose your child, if you lose your mother, isn't it really the same at the end of the day? The kind of a life forever transformed? Why do we have the hierarchy? Does it matter?
Yeah. Just to recapitulate that genocide is a crime which requires that the perpetrator has the intent to destroy a group of people for different reasons. And to that intent is really an extraordinary, serious matter, that kind of crime. Some of you will know that old slogan that genocide is the crime of crimes, is on the top level. And genocide also has this kind of stigma attached to it for the reason I just mentioned. So in a way, that leads to the fact that there is a lot of attention to that crime. And in addition, people do not always distinguish clearly whether they use genocide in the legal sense, where, for instance, intent, as I said, is necessary. Was it the intent? In any conflict, many people are killed, often a large number, but that's not enough to find genocide. So sometimes people use genocide in a bit wider sense, and it's also a way to. So that is the reason, I think. But it is clearly attached stigma to it, and I think this explains why there is so much attention to it. And then to the issue, does it matter? Well, that's a good question. I think at least it matters to lawyers because it's this enormous degree of seriousness between the crimes. And I think it also matters to the persons that are affected by these crimes. It's quite a different matter to a killing and that something happened as part of genocide. And it's, I think, a value for the person concerned, the victims, the family, that it is that the court finds or doesn't find whether it's genocide or not.
And so for the findings for genocide at ICTR, In your view, what did they achieve for Rwanda, for the African continent? Did they have a significance beyond that when you look back?
Let me say first that Rwanda was a bit different from the other special courts because the Rwanda Tribunal more or less was a genocide court. In the other tribunals, even if there were genocide cases also at the ICTY, the Yugoslav Tribunal, it wasn't used those provisions as frequently as in the Rwanda Tribunal. It was almost in all cases. So that's it. And that had as a consequence that the tribunal delivered very many judgments, and these were judgments on genocide, like Akayesu, for instance, the first judgment ever, conviction on genocide, interpretation of the convention, for instance, explaining that rape can be one way of systematic rape can be one way of committing genocide. And there are also there are many other interpretative points, so to speak. But that is why this lives on. All this case law from the ICTR and the ICTY has then been taken into account by subsequent tribunals, and is part of the case law, which is now at the ICC, should that occur. And in addition to that, I will mention that whether there is a history, whether there is a genocide in the country, also raises questions of history. Did it happen or did it not happen? Is there an objective truth here? And the fact that the tribunal consistently finds that this is the case has a value in itself. But that's more with respect to one particular country.
Well, let me bring the discussion now to victims, since ultimately justice is about delivering justice for people most affected by the crimes. In your opinion, does international criminal justice actually have the capacity to do that and to do it effectively?
With witnesses?
Victims.
Victims, yes, victims. There has been a development here as well, and that was one of the developments I did not mention in the first question, or the second. Yeah. And that is that, let's start with the two ad hoc tribunals, Yugoslavia and Rwanda. There, of course, many victims appeared before the court as witnesses. And it was striking to see many of them had suffered greatly. Many of them had to have breaks during the proceedings because it was an emotional thing. But what I noted was that most of them really wanted to tell the story and to contribute to the judicial process. So that is in itself a way the witnesses played a role in these proceedings. It was in a way a recognition, if the judgment went their way, of what happened to them. So that's the first point. The second point is that there is reparation is an important question to witnesses. But here I have to first mention that at the ICTR and ICTY, there was no specific legal basis for awarding reparation to victims, and there was no specific legal provision enabling them to participate in the proceedings as victims. And there were no public funds in the UN or elsewhere which could actually give them reparation. So the victims, in a way, were limited to the first role I mentioned. But now things have changed with the ICC, where the victims have a role and where reparations can be dealt with. And I think everyone agrees that reparation is very important for people to move on. And I know of a specific court in the Central African Republic, which is partly international and partly also a hybrid court, both international judges and national. And there they recently awarded compensation, and that allowed not a big amount. They didn't have much fund, but they were buying in order to be able to move on cows, sheep, many of them were peasants, farmers, and to go on with their lives. I think that's a lovely part of that justice can play, in a way, move on after the transitional period.
Can I shift the discussion to perhaps something less lovely and to ask you to talk about perpetrators? I mean, through all of these trials, you must have had a lot of thoughts yourself about perpetrators of extreme crime and atrocity.
Yeah. Well, even if at the Rwanda tribunal I said they were mostly leaders, it is still clear from the whole context that perpetrators were very many people, even if they were not dealt with by our court, people of different standing, from leaders to very ordinary people. And so I think anyone can become a perpetrator. That is always a question we ask ourselves: how do you start doing these things? And there I'm afraid that we should not underestimate the risk that we may, each of us ourselves, be suddenly in a situation where we might be subject to pressure so that we would do it. If you are in a situation which is very tense, a lot of propaganda saying if you are not with us, you are against us, then maybe at the end of the day, the pressure becomes too big. In one of my trials, one of the witnesses referred to a particular case. It was an elderly lady who had never done anything wrong in her life. And the genocide started in April, and in May, June, there was a particular attack in Kigali against the Gaddafi mosque. And on that day, she took a knife from the kitchen, went to the mosque where the Tutsis were assembled, as always, in order to be killed or wounded. That was the plan. And she killed one Tutsi. And when interviewed, she said, I felt that it was my day to kill. I think that's something I've never forgotten. Again, this was not on the witnesses I had in the courtroom, but it's part of a true story which was conveyed in the courtroom. And in a way, I think, who are the perpetrators? It answers, but this is not the normal situation.
So what you're saying, it could be everybody?
It could be everybody.
And that resisting is not an easy feat?
There will always be some that manage, but it really requires a lot of courage, stamina, and maybe risk for your own security and even your life to resist in some situation. Yeah.
It's complicated.
Complicated.
And I was wondering if you could actually now, since we have you here, shift and talk about the Commission of Inquiry. Because what's really interesting about these commissions is they're doing real-time investigations in conflicts. And I was wondering if you could talk about the aims of these bodies and how they work.
Yeah. Okay. The Commission of Inquiry, as I mentioned in my introduction, there are many commissions of inquiry. But this one, the one on Ukraine, was established not in connection with the invasion in 2014 in Ukraine, but after the full-scale invasion in 2 years ago, and 3 years ago. And it is established by the Human Rights Council in Geneva, as you know. And such a commission has 3 members. In my commission, it's in addition to me, it's one from Colombia working in New York. And there is the current 3rd member is an excellent barrister from New Delhi, India. So we have our meetings by video conferences when we are not on mission, finding 3 o'clock to be the best time because that is workable for 3 continents. We also have a secretariat of which was it was 24. Now the number is lower, but it's about. Now I think we are 13 because of budgetary crisis in the UN, but still we have a good secretariat. They are excellent people, investigators with a lot of competence, children, digital competence, pathology, and so forth. So that's it. What is our role? What is our aim? Our role is to investigate the situation in Ukraine and find out whether what has happened. In addition to investigating, it's also a matter of securing the evidence and also after collecting it, to secure the evidence so that it can be available. And after having to other entities that want to get information, for instance, with a view to criminal cases. And then we draw our legal conclusions. Is this a war crime? Is this a crime against humanity? That's what we also do. And in addition, we decide whether we try to list perpetrators when we have the identity of persons that we discover during our investigations, and we are giving some general consideration, general recommendation. Let me just stress that it's absolutely essential that such a commission is independent and impartial. That is essential for its legitimacy, and that is something we really emphasize. And we also are concerned about the victim-centered approach. That's something we always do. We have been almost many times in Ukraine, and we send our reports to the General Assembly and to the Human Rights Council. We have now submitted 10 reports. The 10th reports, or more specifically, the 10th report comes in March this year, and that will be the end of the 3rd mandate of this commission. So in other words, we have now been working on this for soon 3 years. And it's a very interesting but time-demanding exercise.
Well, can I ask you a technical question? When you're in these situations where you have a vast amount of human rights and violations and humanitarian law violations, how do you actually investigate them? I mean, what do you do?
I think we can make a distinction between, on the one hand, investigation a long time after the event, and on the other hand, investigation during the events. These are 2 different scenarios. Rwanda is an example of the former. The Commission is an example of the latter. So I would, but there are many similarities between the 2 situations. Of course, witness testimony is of the essence, and the testimony by witnesses will normally have to be corroborated by other witnesses or other material. And whenever you have a witness in the courtroom, there will often be some kind of communication problems, cultural problems, whatever, and that's something that has to be taken into account. But it's manageable. It's manageable, just to illustrate that point about how do you investigate if a witness is not exactly on your same wavelength. In Rwanda, there are quite a few persons that would not, at least at that time, have a watch. And when asked during legal proceedings or by investigators, when did this happen, which is essential, whether the accused was there at that time or not, the person would answer, I couldn't answer that question, I don't want to lie, I don't have a watch. But then the question, okay, you have to respect that, but still you need to know what he saw and when. So then, for instance, you ask, yes, but when do you eat breakfast in the morning? Yes. When do you eat breakfast? 9 o'clock, 7 o'clock, 5 o'clock. Was this before or after? It was before or after. And then you relate that to the public knowledge that in April 1994, the sun rose at that particular time, and suddenly you have an idea. So it's complicated, but it's also quite inspirational, frankly, to try to circle in the time. Now, let me now move to investigations in real time, in parallel. That is, for instance, the situation in Ukraine. And there, of course, you deal with witnesses the same way. But let me also mention that when you are in real time, it's easier to find weapon remnants after explosion in order to find out who is most likely to have shot that weapon, which party, which armed party has done that, and so forth. So that is one difference. Another difference is the mass of evidence in a time where the press is covering the conflict and where people are sending in photos and complaining. The Commission has an electronic mailbox where persons can contribute. We get masses of information. And that is a difference compared to more traditional conflicts. And thirdly, the issue of digital evidence. This is a modern conflict, and everything is being filmed, video, everything is on YouTube or whatever, social media rather. And that produces a lot of material. Satellites is also another element here. And then the question becomes, all right, this is in a way fantastic because you get more information. But the problem with these new forms of communication is also that what about their authenticity? Because we all know that pictures may be manipulated. This is something journalists are coping with every day. Can they consider this reliable or not? So this is a third specificity, I would say, in connection with one of many. I could probably mention more, which I would like to mention here.
Well, can I follow up on that and ask you, with these investigations, what have been some of your findings with respect to Ukraine?
Well, as mentioned, 9 reports so far, so one has to be brief. But when it comes to Russian forces, Russian authorities, we have found a wide range of violations of international human rights and international humanitarian law. And torture, taking of life, killing, very many civil and political rights have been violated. But in this context, we should probably mention that some of them also qualify as war crimes. And there is a considerable number that qualify as war crimes. For instance, killings and torture, rape, and transfer or deportation of children. There are many violations in connection with explosive weapons. As you know, a military unit will have to distinguish between civil and military targets. And if you don't follow that principle of distinction or the principle of proportionality, you do it too much, then that is a violation. So that is one kind. of which we have found several on the Russian side. We've also noted that since the 10th of October 2022, there has been a lot of attacks against energy-related infrastructure, and these are serious violations. And finally, let me mention that we have also found crimes against humanity. That was something we mentioned for the first time in a report to the General Assembly in October this year. And there we found that the Russian use of torture against prisoners of war, both, as with other words, military personnel from Ukraine, captivated and kept by the Russian partly in Ukraine, or perhaps later then transferred to Ukraine. There the torture was widespread and systematic, and also a function of a policy, so it qualifies as crimes against humanity. On the Ukrainian sides, we have found a very limited number of violations, but for instance, some examples relating to explosive weapons, with other words, distinction principle, and we have some examples of ill treatment and also crimes, ill treatment relating to collaborators, people that are suspected of collaborating with the Russian side. So that's that. And let me simply say that our methodology is to go into the countries. We have been there, as I said, 30 times, a large number of witnesses, but it's difficult to investigate if a party is not cooperating. Ukraine is cooperating and let us go everywhere. Unfortunately, Russia is not doing so, so we can't go to Russian territory. It makes it a bit more difficult to investigate, but on the other hand, we can get information in other ways. For instance, video, to some extent video, and also interviews with people when they are out of those territories. And Mariupol is a good example. Mariupol, as you know, is in Donetsk region of Ukraine. And in the beginning, since we didn't come in already at the beginning and not later, but subsequently we were able to interview, I think it was 80 persons who had been there during that period. So that is, in a way, the very brief overview of our findings.
Well, thank you, Erik. You've done a really wonderful job of walking us through the contemporary history of international criminal justice in a really short period of time. And what I'd like to do, I've been monopolizing the question here, it's a real privilege, but I'd like to open the floor now